Welcome to Concerned Citizens Presents. Concerned Citizens of Laguna Woods is an organization dedicated to peace, economic and social justice, good government, and a clean environment. Every month, we invite an expert to enlighten us on a topic related to our mission. Because Village TV videotapes these presentations, we can share that expertise with a larger audience. We hope you enjoy today's broadcast.
43% of the cases were 6-3, with the three dissenting justices being Justices Sotomayor, Kagan, and Jackson. That also is double the percentage of cases that were ideologically divided 6-3 from just the year before. I can put this another way. 43% of the decisions were unanimous. If you take out the unanimous ruling, then a very substantial part of the docket was ideologically divided. The justice most often in the majority was Chief Justice John Roberts. He was the majority in 95% of the cases. This reflects, I think, that it is the Roberts Court, not just in name only. Second observation, before I get to specific cases, is that I think the most important thing for the future of the Supreme Court is there was not a vacancy this summer. There was a lot of speculation about whether Clarence Thomas, who's 78 years old, or Samuel Alito, who's 76 years old, would retire. They both knew that if they'd stepped down this summer with a Republican president and a Republican Senate, a young conservative, someone in his or her late 40s, early 50s, would take their place on the bench. They both lived through the experience of Justice Ruth Bader Ginsburg. I have a story for you here. In March of 2014, I wrote an op-ed in the Los Angeles Times urging Justice Ginsburg to retire that summer. I said, with a Democratic president and a Democratic Senate, anyone President Obama nominates will be able to be confirmed by the Senate. I said, if she wants someone with her values and views to take her place, this is the time to retire. It never occurred to me that a Supreme Court justice would pay any attention to what a law professor in Southern California was saying. But the day of the op-ed, I got a call from a mutual friend, a federal judge, who said, quote, Ruth is not happy with you. She gave several interviews where she said, some, such as Erwin Chemerinsky, say that I should step down, but no one can do the job as well as I can. She gambled. She lost.
Yeah,
she passed away in September of 2020. Very quickly, President Trump nominated a conservative federal court of appeals judge, Amy Coney Barrett, to replace her. Rapidly, the Senate confirmed Barrett. Nonetheless, neither Thomas nor Alito retired this summer. If they had both retired, then, and assuming they were replaced by somebody in the late 40s, early 50s, we would have a conservative court for decades to come. Brett Kavanaugh is 60, Neil Gorsuch is 58, Amy Coney Barrett is 54. It's still possible that if the Democrats take the Senate in November, especially Justice Alito might retire, try to get someone confirmed before the Senate changes hands in January. But at least it has to happen so far. The third thing I wanted to talk about concerns President Trump and what a large percentage of the Supreme Court's docket is now focusing on challenges to the Trump administration. Since January 20th, 2025, the day of the inauguration for this term, by my count, there have been 31 matters resolved by the Supreme Court involving challenges to the Trump administration. In 26 of 31, the Supreme Court has ruled in favor of the Trump administration. In 5, they ruled against the Trump administration. Most of these 31 have been on the emergency, the shadow docket. And yet, it's important to note that this term, both on the emergency docket and on the so-called merits docket, cases resolved after a brief and oral argument, President Trump both won and lost some important cases. Let me talk to you about 5 cases this term, and I'll do them in chronological order. And you'll see what I mean, and you'll see why I started by saying it could have been worse. The first of the rulings came on September 8th, 2025. It was Nome versus Perdomo. A federal district court judge in Los Angeles, Judge Frimpong, found that ICE agents were stopping people without reasonable suspicion. Before any law enforcement, federal, state, or local, can stop a person, there has to be at least reasonable suspicion that they've committed a crime or about to commit a crime. Judge Frimpong found that ICE agents were stopping people based on 4 factors: their apparent race or ethnicity, the language they spoke and whether they had an accent, the kind of job they worked at, and where they were found by the ICE agents. Judge Frimpong said these factors, individually and collectively, don't add up to reasonable suspicion, and ICE can't use them. The United States immediately went to the Federal Court of Appeals for an emergency stay of the preliminary injunction. The Court of Appeals quickly scheduled oral argument for Monday, and on that Friday, the Court of Appeals held the preliminary injunction. The government went to the Supreme Court. And on Monday, September 8th, in a 6-3 ruling, the Supreme Court stayed the preliminary injunction. That means that ICE agents can engage in racial profiling. There was no opinion of the court, not a word of explanation. It's one of the things that's often so disturbing about the shadow docket. The Supreme Court issuing major rulings that affect people's lives without giving an explanation. Judicial opinions matter. They give guidance to the parties, to the lower courts. Because I said so was never persuasive to any of us as children, and it doesn't become more persuasive when it comes from the United States Supreme Court. Justice Brett Kavanaugh wrote an opinion just for himself, where he said he explained why he voted in favor of ICE. He essentially said, it's no big deal to get stopped by ICE agents. Unless you're illegally, what do you have to worry about? As a result of the Kavanaugh opinion, these have come to be called, much to his chagrin, Kavanaugh stops. Justice Sonia Sotomayor wrote a blistering dissent, and her point was, no one should ever be stopped by the police just because of their race. In the fall semester, I was teaching criminal procedure, and since this was all about the Fourth Amendment, I began class on Tuesday, September 9th, by reading great large sections of both the majority opinion, Justice Kavanaugh's opinion, and the dissenting opinion. A woman raised her hand and said, my father is retired. He lives in Los Angeles. He's Latino. He speaks with an accent. He's a citizen. He likes now to do projects around the home, and he often goes to places like Builder's Emporium or Ace Hardware. Said, I am worried every day that he'll get picked up by ICE. And she burst into tears. Another student told a similar story in class. The next day, a student came to me. His mother had been apprehended by ICE. She was released 2 days later. That's the result of the Supreme Court's ruling in Nome versus Perdomo. The second ruling I was going to talk about came down on Tuesday, December 23rd. It was Trump versus Illinois. You'll remember that in June of 2025, President Trump federalized the California Guard and sent them and the United States military into Los Angeles. In the fall of 2025, he did that in Portland, and then he did it in Chicago. He federalized the Illinois Guard and used them and the Texas National Guard that Governor Abbott sent there into Chicago. A federal district court ruled this illegal. The Federal Court of Appeals agreed, and the Supreme Court, in a 6-3 ruling, also agreed with the lower courts that President Trump's use of the military in this way was illegal. It was an opinion of the court. That means no single justice wrote it. It's called a per curiam opinion. There were dissenting opinions by Justices Thomas, Alito, and Gorsuch. The Supreme Court said, under federal statutes, the president can do this only if both of 2 requirements are met. First, the president can federalize a state's guard only if he's shown that the use of the regular force of the military would be inadequate. And second, he can do so only if it's a situation where the regular force of the military could be deployed for that purpose. As to the former, hard to imagine the situation where the military wouldn't be sufficient, and so you'd need the National Guard. As to the latter, the court pointed to a very important statute from 1878, the Posse Comitatus Act. It prohibits the use of the military for domestic law enforcement purposes. The Supreme Court thus said that a president can federalize the state's guard and use them as President Trump did in Chicago, Portland, Los Angeles, only if the Posse Comitatus Act was met. Bottom line is, only if a president would invoke the Insurrection Act could a president do this. So far, President Trump has complied with this. He has not deployed troops in any other city. The only place where there's federal troops now is in Washington, D.C., which is a different status because it's not a state. It's a part of the federal government. I think this is a very important ruling of the court limiting President Trump. The third example that I was going to point to with regard to President Trump came down on Friday, February 20th. It's learning resources versus Trump. It involved the tariffs that President Trump imposed. As you know, tariffs have been a crucial part of President Trump's economic and foreign policy. In his brief to the Supreme Court, he said that it's essential to the country's economy to be able to impose these tariffs. The Supreme Court, in a 6-3 decision, ruled that President Trump's tariffs were illegal. Chief Justice Roberts wrote for the court. There were concurring opinions by Justices Kagan, Gorsuch, and Barrett. Justice Thomas wrote a dissent, joined by Justice Alito. Justice Kavanaugh wrote a dissent, joined by Justice Thomas and Alito. To start with, it's important to emphasize that all 9 justices agreed that the president lacks the inherent power to impose tariffs. In order for the president to impose tariffs, there has to be a federal statute authorizing that. So the question in this case, was there such a federal statute? President Trump pointed to the International Emergency Economic Powers Act. This allows the president to, quote, regulate importation. Chief Justice Roberts, writing for a 6-person majority, said, regulate importation isn't specific enough to authorize tariffs. He said what Congress wanted to give the president the power to impose tariffs, it used the word tariffs. He said that the power to tax belongs to Congress and tariffs are a form of tax. The dissenting justices would have allowed the president to use this statute for tariffs. Now, one of the important questions is, what about all of the tariffs that were illegally collected? The court didn't talk about that, but there's been a lot of litigation, and at least some of the tariffs have been returned. The day the decision came down, President Trump attacked the Supreme Court in unprecedented vituperative terms and then imposed new tariffs. Those tariffs were enjoined by the lower court and then expired. And now President Trump has imposed even additional tariffs, and they're being challenged in court. But I think this is an important case, again, ruling against the Trump administration. The fourth case that I wanted to mention with regard to Trump in the Supreme Court is a very important victory for President Trump and an expansion of presidential power. The case is Trump versus Slaughter, and it came down on Monday, June 29th. In 1935, in Humphrey's Executor versus United States, the Supreme Court said that Congress can create federal agencies, and Congress can provide that the members of the agency can be fired only for cause. This involved a commissioner on the Federal Trade Commission, been appointed by President Herbert Hoover, was very loyal to Hoover, very critical of Roosevelt. The Federal Trade Commission Act says a commissioner can be fired only for cause, and the statute defines cause. Roosevelt fired that commissioner. the Supreme Court unanimously ruled against Roosevelt and in favor of the commissioner. The Supreme Court said Congress, in carrying out its policies, can provide that heads of agencies can be removed only for cause. And there are countless agencies where this is so. The National Labor Relations Board, the Federal Communications Commission, the Securities and Exchange Commission. In Trump v. Slaughter on June 29th, the Supreme Court, in a 6-3 decision, overruled Humphrey's executive. Chief Justice Roberts wrote the opinion for the court. Justice Sotomayor wrote the dissent. Chief Justice Roberts said, it's a unitary executive. He said that the Constitution says that all executive power is vested in the president, and therefore the president should be able to fire anyone in the executive branch. Not only does this overrule 90 years of precedent, but when the Supreme Court had considered it previously, it rejected the so-called unitary executive theory. Justice Sotomayor, in her dissent, lamented the Supreme Court again ignoring long-standing precedent and talked about this is a tremendous shift in power from the president, from Congress to the president, and an increase in presidential authority. I think the key question after Trump v. Slaughter is when, if at all, can Congress limit the removal of power? Does this literally mean that the president can fire anyone in the executive branch? Does it mean that civil service protections that have existed since the late 19th century, protecting against firing of government employees, are also unconstitutional? The court decided another case that same Monday, June 29th, Trump v. Cook. In fact, in the Supreme Court's press room, when they gave out the decisions, they rubber banded together Trump v. Slaughter and Trump v. Cook. The reporters said they'd never seen that before. Trump v. Cook involves Lisa Cook. She's a governor on the Federal Reserve Board. The law there says they can be fired only for cause. President Trump asserted that she'd engaged in mortgage fraud and therefore was going to fire her. There's no finding by any court or any agency that she'd engaged in mortgage fraud. She sued and she won in the Supreme Court in a 5-4 decision. Chief Justice Roberts wrote the opinion for the court. He said, the Federal Reserve Board can trace its origins back to the first Bank of the United States in the presidency of George Washington. He said it's so essential that the Fed have independence in setting interest rates. But then he said that the holding of the case was narrow. All the court was holding was that Lisa Cook had a right to notice and an opportunity to be heard before she was fired. Well, you might have seen just last weekend, President Trump is again trying to fire Lisa Cook, again trying to circumvent what the Supreme Court has said. Where the limit, if any, that Congress can draw on removal power is unknown, but Trump v. Slaughter is certainly a great expansion of presidential executive power. The fifth and final area of cases about President Trump I want to talk about came down on Tuesday, June 30th, and the case is Trump versus Barbara. It involves President Trump's order on birthright citizenship. When the country began in 1787, it followed English law that everyone born in the country was a United States citizen. This was followed without exception till 1857, when the Supreme Court handed down its tragic decision in Dred Scott versus Sanford. There the court held that enslaved individuals were not United States citizens, even if born in this country. A decade later, when the 14th Amendment was drafted and then ratified in 1868, it says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States in the state wherein they reside. It was understood from 1868 until January 20th, 2025, that everyone born in the United States, with only very limited exceptions, was a United States citizen. Indeed, in 1940, Congress passed a statute simply copying the language of the first sentence of Section 1 of the 14th Amendment. This was reenacted as the Immigration Act of 1952. But on January 20th, 2025, President Trump issued an executive order that essentially said only those born to citizens and those with green cards, long-term lawful residents of the United States, are citizens. Or put another way, if someone in the country on a visa had a baby, or someone undocumented had a baby, those children would not be citizens. Every federal district court to consider this, every federal court of appeals to consider it, declared the executive order unconstitutional. On June 30th, so did the Supreme Court. 5 justices said that the executive order is unconstitutional. Roberts wrote the opinion for the court. It was joined by Justice Sotomayor, Kagan, Jackson, and Barrett. Justice Kavanaugh said that he believed that the executive order was constitutional, but he struck it down as violating the federal statute. Justice Thomas, Alito, and Gorsuch dissented. The surprise to me is that this wasn't 9-0. This is such a clear constitutional question. Chief Justice Roberts outlined why. The history that I mentioned, the text of the 14th Amendment and its history. There is a precedent from 1898, United States versus Wong Kim Ark. There the Supreme Court said everyone born in the United States is a citizen. The court said the phrase subject to the jurisdiction thereof just means if there's an invading army and a soldier had a baby, or there's a foreign diplomat who had a baby, they would not be citizens. Chief Justice Roberts said, other than that, everyone born in this country is a citizen. I said Justice Kavanaugh would have ruled against Trump based on the federal law. He said when Congress adopted the statute, it knew what the Supreme Court had already said in defining the language. Justice Thomas Alito and Gorsuch would have ruled in favor of President Trump. You might have seen that, again, last week, President Trump issued an executive order to try to circumvent the Supreme Court's decision. It says, for example, that those who are in the United States for so-called birth tourism reasons, the parent comes here to create citizenship, aren't citizens. That's clearly unconstitutional based on what the Supreme Court said. The Trump executive order says anyone who's deemed to be part of a foreign terrorist organization as a baby, that child not a citizen. That's inconsistent with what the Supreme Court said. So I think that we're going to see more litigation about this, but I don't foresee the Supreme Court backing off of its decision. So when you look at the decisions concerning President Trump, there were some really important ones where the Supreme Court ruled in favor of him, but also some important ones where the Supreme Court went against President Trump. The fourth area I want to talk about concerns voting rights. And if you ask me what was the most important Supreme Court decision last year, I would say without hesitation the court's ruling in Louisiana versus Calais on April 29th. Let me put this in a broader historical context. The 15th Amendment, adopted in 1870, said that the right to vote shall not be infringed on account of race or previous condition of servitude. But that was a hollow promise. In 1964, in Mississippi, only 7.6% of eligible black individuals were registered to vote. In Alabama, it was 17%. Across the South, what had been the Confederacy, only 43% of eligible black people were registered to vote. The Voting Rights Act of 1965 was meant to change that, and it did so dramatically. The Voting Rights Act had 2 crucial provisions. Section 2 says that state and local governments can't have election systems that discriminate against voters of color. In 1982, Congress amended that to say that proof of racially discriminatory impact would be sufficient for a violation. There didn't have to be proof of a racially discriminatory intent. It's so difficult to prove discriminatory intent. And Section 5 of the Voting Rights Act said, for jurisdictions with a history of race discrimination in voting, they would need to get pre-approval, pre-clearance for anything that change their election system from the Attorney General of the United States. In June of 2013, in Shelby County versus Holder, the Supreme Court declared unconstitutional the provisions of Section 5, the pre-clearance requirement. Since then, no jurisdiction is needed to get pre-clearance. Chief Justice Roberts, in his opinion, said, but there's still Section 2 that says the state and local governments can't have election systems with a discriminatory impact against voters of color. Louisiana versus Calais dramatically weakened that provision. Louisiana versus Calais involves congressional districts in that state. There are 6 congressional districts in Louisiana. After the 2020 census, Louisiana, like every state, engaged in redistricting. Under the new map, 1 out of the 6 districts in Louisiana would have a majority black population. The population of Louisiana is about 35% black people. A lawsuit got brought arguing that this violated Section 2 of the Voting Rights Act, that it had a racially discriminatory effect against voters of color. When there's a challenge to districting, it goes through an unusual procedure of a 3-judge federal district court. This went to a 3-judge federal district court, and it found that Louisiana violated the Voting Rights Act. The Louisiana legislature then redrew its congressional districts, and they created 2 districts that were majority black individuals. Some white plaintiffs brought a challenge and said that this violates equal protection. The Supreme Court had previously said that the government can't use race as a predominant factor in drawing election districts, or it violates equal protection. The 3-judge federal court said, you're right, to have 2 districts that are majority black violates equal protection. Louisiana then went to the Supreme Court and said, just tell us what to do. When we had 1 majority black district, we violated the Voting Rights Act. When we had 2, we violated equal protection. And the Supreme Court held oral arguments the term before, in October term 2024. And on Friday, June 27th, to the surprise of everyone, the Supreme Court didn't decide it. The court said, we want to hear it again next year. And they had oral arguments on October 15th. And as I said, on April 29th, the Supreme Court, in a 6-3 decision, ruled that Louisiana violated equal protection by creating 2 districts that were majority black individuals. Justice Alito wrote for the court. Justice Kagan wrote a blistering dissent. Justice Alito said that Louisiana violated equal protection in using race as a predominant factor in drawing election districts. The court said a state cannot do this even if its goal is to avoid violating Section 2 of the Voting Rights Act. He said in order for a state to be able to do this, it has to prove that there was intentional race discrimination. Just showing a racially discriminatory impact isn't enough. Justice Kagan said, it's so often difficult, even impossible, to prove a discriminatory intent. Rarely will legislators express that as their purpose. Rarely will they express a racist motive. But then Justice Alito went even further, and he said that if the state is drawing election districts for the purpose of giving a political party a partisan advantage, then there's not a discriminatory intent. So if the purpose of the legislature is to create more safe seats for Republicans, that then refutes there being a discriminatory intent based on race. Justice Kagan, in her sense, says there's such a correspondence between race and party, especially in southern states. Black individuals vote Democratic over 90% of the time. She points out that then any time the government wants to discriminate based on race in drawing districts, they can just say it's doing so to give a partisan advantage to Republicans. The practical effect of this decision is going to mean the largest loss of black representation in Congress and in state legislatures since the end of Reconstruction. The only path now with regard to voting and districting is to be able to allege and prove that there was a racially discriminatory intent. But in another case, this one from the emergency docket, the Supreme Court made that much more difficult. The case here is Allen versus Milligan. It involves the drawing of congressional districts in Alabama. There's been a great deal of litigation about it. Three-judge court found that Alabama violated the Voting Rights Act because there was a discriminatory effect against black voters. After the Supreme Court decided Louisiana versus Clay, the Supreme Court sent Allen versus Milligan back to the lower court for reconsideration. Quickly, the lower court ruled that Alabama had acted with a racially discriminatory intent against black voters. It wrote a 78-page opinion. It was based on a lengthy hearing and a great deal of evidence that demonstrated that Alabama had used race impermissibly in drawing districting to the disadvantage of black voters. It's exactly what would seem to be left after Louisiana versus Clay, a finding of intentional race discrimination. But the Supreme Court, 6-3, reversed the lower court and allowed the discriminatory district to be used in Alabama. Again, it was an opinion of the court, so-called per curiam opinion. Justice Sotomayor wrote a scathing dissent. And what the Supreme Court said was that the three-judge court didn't give sufficient deference to the Alabama legislature. That there be much more deference to the legislature in its districting. So even when a federal court found intentional race discrimination, still the Supreme Court wasn't willing to find a violation of the Voting Rights Act or the Constitution. This is going to make it so very difficult to challenge election systems as violating the Voting Rights Act in the future. As I say, it's going to have a devastating effect with regard to minority voters, with regard to voting rights. The fifth and final area that I want to talk about concerned the culture wars coming to the Supreme Court. There's probably no issue more central to the culture wars now than that about the rights of transgender individuals. The Supreme Court decided 2 cases this term that touched on this. In both, transgender individuals lost. In fact, to put this in a broader context of the last few years, there have been many Supreme Court cases involving rights of transgender individuals, and the Supreme Court has consistently ruled against transgender individuals. In the spring of 2025, there was Trump versus Schilling. President Trump issued an executive order excluding transgender individuals from the military. Federal District Court issued a preliminary injunction. Federal Court of Appeals upheld it. But the Supreme Court, 6-3, again without an opinion or explanation, reversed the lower courts. Then there was United States versus Scrimetti in June of 2025. It involved the Tennessee law prohibiting gender-affirming care for transgender youth. 6-3, the Supreme Court upheld it as constitutional. Then in November 2025, there was Trump versus Orr. The State Department adopted a rule requiring that a person's sex as assigned as birth be listed on their passport. Federal District Court had issued a temporary restraining order. The District Court said the purpose of the passport is identification at the time it's presented. Makes sense you'd want to have the person's gender identity reflected in the passport. The District Court said requiring that transgender individuals listed in their passport their sex assigned at birth could subject them to harassment and even violence in some foreign countries. The Supreme Court, 6-3, stayed the lower court and allowed the State Department to do this. There was Mirabella versus Bonta in March of 2026. What this involved was a California law that said that schools should not inform parents of students' preferred gender pronouns or gender identity without the student's permission. The lower courts upheld this. The Supreme Court issued a preliminary injunction against it, making clear that it was likely to strike it down. Well, in this context, there were two cases this term that dealt with transgender rights on the merits docket. One was Childs versus Salazar. Colorado adopted a law that prohibited conversion therapy for gay, lesbian, and transgender youth. The Colorado legislature found that such conversion therapy is ineffective and harmful. A therapist who engages in talk therapy wanted to challenge this. She said, we want to engage in such therapy, try to change people's gender identity or sexual orientation. The Federal Court of Appeals upheld the law. The Federal Court of Appeals said that Colorado had found that this therapy is ineffective and harmful, and that the government regulates professional speech in many ways. You should be able to do so here. The Supreme Court, and it was an 8-1 decision, reversed. Justice Gorsuch wrote for the court, only Justice Jackson dissented. Justice Gorsuch said, this is a content-based restriction on speech. If a therapist wants to engage in speech to reinforce someone's sexual orientation or gender identity, that's allowed. But if the therapist wants to change somebody's sexual orientation or gender identity, that's not allowed. He said, content-based restrictions on speech must meet what's called strict scrutiny. They have to be necessary to achieve a compelling purpose. And he said that was not met here. Justice Jackson in her dissent said, as at the Federal Court of Appeals, there's so many ways in which the government regulates professional speech. Doctors have to give warnings for treatment before prescribing medicine. Lawyers have to inform clients of enough that they can make informed choices. If a therapist knows that a patient is a threat to a third person, the patient has to warn the third person. Or imagine a simple example. Imagine the state has a law that says that no therapist can encourage suicide. Speech that would prohibit suicide would be treated one way, speech that would encourage suicide another. Or imagine laws with regard to anorexia. Of course the government can be content-based in this way. And Justice Jackson says any such laws are not vulnerable. And she stressed, as had the lower court, the state's interest in preventing therapy that is proven to be ineffective and harmful. The final case with regard to gender identity came down on Tuesday, June 30th, and this is West Virginia versus BPJ. It involves a West Virginia law that transgender girls and women cannot participate in girls and women's sports. BPJ is a teenager in West Virginia. She identified as having gender dysphoria at age 9. She began taking male puberty-blocking hormones at age 10. She began then taking female hormones. She wishes to participate in girls' sports. She's not allowed to because of the West Virginia law. The lower courts ruled in her favor, but the Supreme Court, in a 6-3 decision, reversed and ruled against her. Here, Justice Kavanaugh wrote the opinion for the court. Justice Sotomayor wrote the dissent. It's interesting, the court treated this case as sex discrimination, not as about gender identity discrimination. And the reason the court gave was to say that under the West Virginia law, a boy can't participate in a girls' sports team. That makes it sex discrimination. A biological male can't participate in girls' sports, even if transgender. The test under constitutional law for sex discrimination is that the government has to show that its action is, quote, substantially related to an important government purpose. Justice Kavanaugh said, West Virginia has important purposes here. It wants to preserve competitive balance for girls and women's sports. He said, wants to prevent transgender girls and women from taking spots away from cisgender girls and women. He said it's about protecting the safety of girls and women in girls and women's sports. Justice Sotomayor in dissent said, the majority is asking the wrong question. The right question in this case is, as to PPJ, a transgender girl who began taking male puberty-blocking hormones at age 10, taking female hormones since then, is there any reason to believe that she has a competitive advantage or that she would pose a safety risk over others? And she says the Supreme Court is asking the wrong question in this regard. But I think to understand this case, you have to put it together with all of the others that I mentioned, where the Supreme Court has consistently entered the culture wars and very hostile to anything that looks like transgender rights. So those were the main areas that I wanted to talk about. I tried to address some of the questions, Suzanne, that you had sent me. I'm glad for my remaining 50 minutes to take questions, or I have more cases that I can talk about.
Well, I think our folks would like some questions. I will just start the ball rolling with one that someone asked me recently. In your opinion, once Democrats have the political power to bring about change, what Supreme Court reforms would you favor?
First, a binding code of ethics for Supreme Court justices, just like there's a binding code of ethics for all other federal state judges. Until just a few years ago, there was no code of ethics for Supreme Court justices. Every judge, state and federal, other than the Supreme Court, had to follow a code of ethics. I think the Supreme Court's very low approval rating is in part a self-inflicted wound based on the lack of a binding ethics code. And when the Supreme Court adopted an ethics code, it was much weaker than that which applies to other judges. There are places where for other judges it says shall, which means it's obligatory, and for Supreme Court justice it says should, which is aspirational. Also, there's no enforcement mechanism for the ethics code for Supreme Court justices. Second, I'd like to see 18-year non-renewable term limits. Some of this is that thankfully life expectancy is a lot longer now than it was in 1787. In 1787, average life expectancy was 37 years. Clarence Thomas was 43 when he was confirmed for the Supreme Court in 1991. If he remains on the court until he's 90, he'll be a justice. That was the age Justice Stevens retired. Thomas will be a justice for 47 years. Lena Kagan was 50 when she was confirmed. If she stays till she's 90, that's 40 years. That's too much power in one person's hands for too long a period of time. Also, too much depends on the accident history when there's a vacancy on the Supreme Court. Jimmy Carter filled no seats on the Supreme Court in his 4 years as president, but Richard Nixon filled 4 seats in his first 2 years as president. Donald Trump filled 3 seats in his first 4-year term, but the prior 3 Democratic presidents, Jimmy Carter, Bill Clinton, and Barack Obama, filled only 4 seats in their combined 20 years in the White House. I would favor staggered 18-year non-renewable terms.
Okay, great. Well, that's a nice agenda. Let's cross our fingers that even a small part gets enacted. Here's an interesting question. The Supreme Court gave the president immunity in his commission of official acts. Considering all that he's done, could you help us understand an official act, and perhaps more specifically, are some of the things he's done possibly could he be held responsible and that they're not official acts?
The case is Trump versus the United States. It was July 1st, 2024. I think it is a terrible Supreme Court decision. I've suggested to my students that there should be a hall of shame of bad Supreme Court decisions. Cases like Dred Scott versus Sanford, Plessy versus Ferguson, Korematsu versus the United States. Trump versus the United States belongs in it. And it says that the president has absolute immunity from criminal prosecution for any official act taken in office. An official act wasn't defined with precision, but it means that anything the president has done in carrying out the powers of the office, that's an official act. So Justice Sotomayor in her dissent said, imagine the president orders the Navy SEALs to assassinate a political rival. Or imagine the president takes a bribe for a pardon. Or imagine the president orders the Justice Department to prosecute someone for political retribution. She ended the sentence by saying, for all of that, immune, immune, immune. What might not be an official act? I think some of the corruption that we've seen, whether President Trump has enriched himself and his family, cryptocurrency deals, I think there's an argument that those weren't official acts. Those were much more personal enrichment. But it would take litigation because the Supreme Court wasn't clear about the line of what's an official act.
Right. Okay. Well, we'll see if that gets pursued. That's an interesting insight. This is more a general question, legal question, and I think many of us are very concerned about the attacks that ICE continues to perpetuate on the population. Is there no legal recourse? Do we have no way of stopping the continued abuse, both within detention facilities and in the process of pushing people into them?
We do have recourse through the courts. Courts can, and some courts have found, that what ICE was doing in detention facilities violates the Constitution. I think it's so important for everyone to be informed and read the articles that describe the truly inhumane conditions in these detention facilities. I don't think it's an exaggeration to call them concentration camps in the United States. Also, some courts have found that ICE behavior has been illegal, but we see constantly what ICE is doing. And my hope would be that Congress would have restrained ICE, but Congress hasn't done that. And in terms of courts, we need much more in the way of courts finding that what ICE is doing is unconstitutional and illegal.
Right. Well, it's a very big disappointment, I think, for all of us that we are so helpless when we see crimes just within our midst. This is a different kind of question. We know that you are involved in the case of, is it pronounced Thacker?
Oh, sure.
Versus Trump. I wonder if you could tell us a little bit about what that case is, why you've taken it, and how you expect it to go.
This is a lawsuit that's been brought on behalf of University of California faculty and researchers who had their grants cut off. I'm one of the attorneys, along with another professor here at Berkeley, Claudia Polsky, and two law firms that have done prodigious pro bono work on it, the law firms of Leaf Cabraser and Farella Brown. I argued in federal district court last year on June 20th for a preliminary injunction, and we received a preliminary injunction. I've argued it twice in the Ninth Circuit, and the Ninth Circuit has largely upheld the preliminary injunction, and about $1 billion in grants have been restored to University of California faculty and researchers on all 10 campuses across the state as a result of this litigation. I'm hopeful that we will continue to prevail and they will continue to get grants restored. We've now at the stage of procedurally, we've moved for a permanent injunction. It's on a motion for summary judgment. And part of this is the idea that some of the agencies like the Department of Energy cut off grants in so-called blue states and not in red states. And the government has admitted that. You might have seen there was an article in the New York Times, an article in the LA Times about it, and that was a result of the materials that became public in our case and the government's admission in our case. I had a lot of people call me and say, did you see this article that'll really help your case? And I said, no, it is our case where this has been raised. So I'm hopeful we will continue to prevail. What's disappointing to me is that it was brought by some volunteer law professors and law firms. It wasn't brought by the University of California. And that in other states where grants have been cut off, there haven't been similar suits either by faculty or by the universities.
Right. Well, a lot of passivity, indirect complicity. Um, I don't have any more questions from the audience, so I'm
Oh, I
going
can do more cases.
I'm going to shoot. I'm
Okay.
going to shoot from the hip. Uh,
Okay.
about a year ago, we had your colleague Mario Barnes here, since you don't speak to us anymore. It was in the context of the executive power decision that Mario told us. We asked about the possibility of this horrible decree being reversed. Uh, Surely most Americans don't want unlimited executive power. And what Mario said at the time, and that was before so many more horrible decisions, he said precedent is really important in Supreme Court adjudications. And that once a precedent has been established, it's extremely difficult and people are reluctant to turn it around. Well, now we have a massive list of horrendous decisions, all of which need to be reversed. Is this a Sisyphus task, or is there some possibility that these things could be turned around?
The key is the composition of the Supreme Court. I mentioned Justice Thomas is 78, Justice Alito is 76, Justice Roberts is 71, Justice Kavanaugh is 60, Justice Gorsuch is 58, Justice Barrett is 54. Easy to imagine this court being there another 10 years. And again, if Thomas and or Alito are replaced by young conservatives, then we can imagine having a conservative majority for 20 or more years. The only way of overruling the decisions is going to be a different court, and that's not on the horizon for any time soon.
Oh dear. Okay. Here's one from the audience. You kind of just spoke to it. What are law school deans doing collectively to protect the court and lawyers from abuse?
The hard word in that question is collectively. That I think we're doing a lot in our school. Some of the deans are doing a lot in their schools. And here at Berkeley, we've created the Christopher Edley Center on Law and Democracy that's doing wonderful work in all sorts of ways. We're just hiring lawyers to bring litigation. They do white papers and programs. They're doing a symposia, both in Berkeley and on the East Coast, for state attorney generals and city attorneys on how to push back against the Trump administration. We have law professors doing terrific work in the immigration area and the like. Collectively is the hard part there. And I'll tell a story. In the spring of 2025, when President Trump targeted law firms just because of who they had represented, I tried to organize a dean's letter, and it was a very mild letter. It just said that lawyers should not be punished for the clients they represent or for their lawful, zealous advocacy. I could get only 78 out of 196 law school deans to sign that letter. And of the so-called elite schools, only the deans of Georgetown, Cornell, UCLA, and Berkeley signed. This past spring, there was an attempt by a group of deans, and I wasn't one of the organizers, though I signed, to have a letter just about the rule of law, and even fewer deans signed. So it is really hard to get deans to do anything collectively.
Right. Okay. All right. One last question, and then we'll let you go. This is fairly specific. In your opinion, once Democrats have the political power to pass some sort of campaign finance reform, do you think the Supreme Court would rule such legislation unconstitutional?
It depends on what it is. I think if it's any meaningful campaign finance reform legislation that would really make a difference, it's likely to be struck down by the Supreme Court. There was a campaign finance case this year. It was on June 30th. It was National Republican Senatorial Committee versus Federal Election Commission. It involved a federal law that prohibited political parties from coordinating expenses with candidates, and the Supreme Court 6-3 struck it down. I think for truly meaningful campaign finance reform, we're going to need a different Supreme Court.
Well, thank you so much for another wonderful presentation.
My pleasure. And I'll look forward to next year, which I think will then be like the 19th.
Good. And we'll see you next year.
I look forward to it. Thank
Okay.
you.
Thank you very much.
Thank you.
Bye.